baby boy. Hello everyone, welcome back to the channel. Welcome if you're new. My name is Pluto and I am a lawyer based in Australia. And for today's video, I'm going to be breaking down essentially the closing arguments presented by both sides in the Johnny Depp versus Amber Heard defamation trial. Starting off with Johnny's side, Camille and Ben. I'm going to probably blend in what they both said rather than follow the structure by the book so that it flows better. But essentially, they went for the emotional appeal. And I mean that literally, by the way, because they both did get emotional during their submissions, particularly towards the end. They implored the jury to give Johnny's life back to him, to help clear his name. As is normally the case with closing arguments, they put forth their strongest evidence to back up each submission that they made during closing. So, for example, when Camille would say that Amber Heard was the abuser, she was the perpetrator, she was the one who admitted during contemporaneous recordings to physically assaulting Johnny and starting physical fights. They would then play the evidence, play the audio clips immediately after these submissions to reinforce the point, to really drive it home, which is the point of closing arguments. To give the jury everything you've got before they retire for deliberations to maximize the chances of them making a finding that is for your client. And so the main point of this closing was to tell the jury who the abuser is. The entire narrative has been flipped in the sense that Amber is the perpetrator and Johnny is her victim. Of course, they played that clip as well. Tell the world, Johnny. Tell the world and see who will believe you. And that was a powerful moment because she said, tell the court, tell the jury, tell the world. Not even imagining in her wildest dreams that 6 years later, 6 years to the day since she got that TRO, Johnny was doing exactly that. The lack of evidence on Amber's part was brought to the forefront. All of her inconsistencies, the fact that her narrative keeps changing, the fact that the only person who came to court to support her in person was her own sister. Everyone else had cut ties. That was mentioned, again, to show that this woman burns bridges. She's not credible. She has a history of lying. In fact, Camille did this thing where she listed all of the witnesses whose testimony directly contradicts Amber's testimony. So essentially, she told the jury, you either believe Amber and find that everyone else committed perjury, or the alternative is crystal clear, of course. Mention was also made about how the lack of evidence, particularly in this instance, is all the more bizarre because of who we're dealing with here. We're dealing with Amber Heard. We're dealing with someone who does document things. She documented Johnny Depp falling asleep. I mean, God knows for what reason. These photos span as far back as 2014, if not earlier. So if she had the foresight or the presence of mind to document him when he was falling asleep, to film him when he's slamming kitchen cabinets, why didn't she document any of the horrific injuries she allegedly sustained, even if she never went to seek medical treatment, which renders her allegations all the more ridiculous, especially when you consider how horrific they were. I'm talking about the Australia one in particular, by the way. But besides that, why not document your injuries? Why take the time to photograph a mirror with messages rather than your own injuries? And why take the care to make sure that you're not in that photo, you're not in the reflection? Now, their stance wasn't just to point out that all of her evidence was severely lacking or doctored. With the 15th of December 2015, for instance, we know that Melanie Iglesias, who came across as a very credible witness, was insistent that Amber was injured. And so I think Johnny's team dealt with it in a clever way, which is, yeah, she could have been injured, not as horrifically as she alleged she was. She definitely didn't have a broken nose. Melanie testified that there was slight discoloration under her eyes and some swelling in her lips, which Camille pointed out lines up far more with Johnny's account of an accidental headbutt than an intentional violent attack that led to a broken nose, amongst other injuries. And speaking of photos, they did bring up the fact that none of the photos were authenticated and that they were clearly edited to increase the saturation and make out the redness in her face, for example, to be a lot worse than it actually was. And they tell the jury this: you either believe everything she says or none of it. And this is an argument grounded on the credibility of the witness or the defendant. So in Amber's case, if you make a finding that she lied about one instance, then you're free to believe that she lied about everything else, which I think is a sound argument. Having said that, that's not usually how things play out. And especially in the UK, that's not how things played out, because the judge in that instance believed 12 out of 14 of her allegations. And so he did find that certain allegations were far-fetched, such as the hostage situation in Australia, which she actually left out of the proceedings this time around. In the week leading up to the TRO, they listed all of the witnesses, including the staff at the ECB who owed Johnny no loyalty, who testified that she didn't have any injuries. They also mentioned the fact that she sought a TRO when Johnny was, if not in New York, so halfway across the country, in Europe for the next 2 months on tour. So why would you seek a temporary restraining order when your husband was on the opposite end of the pond? None of it adds up. And that was the main gist of their argument. They're telling the jury that none of this adds up. If you're confused, you should be. If it doesn't make sense to you in your minds, it's because it's senseless. Even Amber herself can't keep track of it and make sense of it anymore. Now, Rottenborn took over. And I have to acknowledge, just from lawyer to lawyer, that he was quite effective, at least with what he had, with what little he had, because his client hasn't really given him much to work with. Let's be fair here. I'm not praising the guy. I still think he's an incredibly tough pill to swallow, and he comes across as extremely unlikable, but at the end of the day, he is a lawyer doing his job. He did his job and may have convinced at least a few of the jurors or swayed them or gave them pause, which is not really going to be helpful in this instance because of actual malice. Now, I've learned something new in closing arguments. Actual malice has an entirely different standard of proof to the rest of the elements of defamation. In a civil case, the standard of proof is the preponderance of the evidence, or, it's a balancing act. On balance, what do you believe more? What's more likely? It's not a very high standard. But the standard for actual malice is clear and convincing evidence. So that means that the evidence must create in the jury's mind a clear conviction that the defendant acted with actual malice. So this isn't on the balance anymore. This is starting to sound a lot like beyond a reasonable doubt in criminal cases, because that's the standard for criminal cases, which is a very high standard. I'm not saying they're equivalent, but it's definitely inching up towards that benchmark of beyond a reasonable doubt. And so Rottenborn's goal was to basically give the jury enough doubt in their minds, not that this is reasonable doubt, this is not a criminal standard, let's not get confused here, but enough to not be convinced that Amber acted with actual malice. He approached the closing with two main points that he really wanted to hammer home. Firstly, he shamed the approach that Johnny's team were pursuing with regards to the lack of evidence on Amber's part. So he opened by saying Johnny's team want the jury to spread the message that no matter what a victim does, it's never good enough to prove their case. If they didn't take photos, it never happened. If they never told anyone, it never happened. If they did take photos, then they were faked. They were photoshopped. It was makeup. So he's basically saying, don't let them set this standard or this precedent that would make it all the more difficult for victims to be believed in an environment where victims already suffer and struggle in that area. And what makes this argument very compelling is the fact that it's grounded in truth. We do live in a world where victims are expected to have sometimes, an unreasonable amount of evidence to back up their claims. Now, on the one hand, it's understandable to avoid miscarriages of justice. We all know false allegations are very much a thing. I mean, look at the case I'm currently talking about. And so we have to have these rigid rules of evidence and standards of proof to minimize the chances of innocent people getting charged, getting convicted. On the other hand, of course, we're placing victims in this impossible situation of, if you didn't document it, then it didn't happen, which is not always possible. He then moved on to an argument that he brought up in the opening statements, but it's otherwise pretty much been abandoned throughout the case until now in closing arguments, which is the First Amendment, freedom of speech. So he's asking the jury, do you want to help set another precedent of shutting down people who want to speak about their personal experiences, who want to exercise their right to express themselves? And so he argued Amber was talking about her experiences after Johnny Depp. This has nothing to do with Johnny Depp. It's not a hit piece on Johnny Depp. He also made it a point to reel in the jury and to remind them what this case is truly about. It's about defamation, specifically the op-ed. And that was clever on his part because it is very easy for all of us, let alone the jury, to get lost in the horrific allegations that have emanated from this case. One can easily mistake it to be a criminal trial to determine who abused whom. But essentially, it all comes down to 3 statements that were made in the op-ed published in the Washington Post. And so Rottenborn's approach was, when you read these 3 statements on their face, so prima facie, they are true. And what he meant by that was, for example, with the first statement where she said, then 2 years ago, I became a public figure representing DV. That's literally true, is what he argued. She did when she went to court with the bruise on her face and got a TRO. Whether her allegations were true or not, she did become a public figure representing DV. So since it's true on its face, it cannot be defamatory. And again, I'm stressing this is his argument, not mine. He applied the same reasoning to the second statement, how then in real time I watched as men in positions of power were protected. I'm paraphrasing, of course. And he said again, especially when you think about the era of the Me Too movement, where all of these allegations have come out, what she said on the face of it was true. With regards to the online title, which is the third statement, where an allegation of SA is made, he argued that, based on the jury instructions, they cannot find that simply retweeting or sharing a hyperlink constitutes republication. Now, this is supported by Virginia law. However, the case law also states that if content is added to transform the work or to add to it, and if it is shared with a new audience, then that constitutes republication. And Ben Chu made that argument in his submissions. Rottenborn argued otherwise. He said that she had no choice but to share the online version because the only other version was the paper version. And how do you share a paper, physical, tangible article on the internet? You can't attach it with a paper clip, is what he said. And so she simply retweeted the only other option that she had, being the online version. And he further argued that whatever she added was simply a blurb to introduce the article, rather than transform it or add to the actual body of the article itself. With regards to the third statement, referencing SA in the title, Rottenborn correctly pointed out that Amber had stated within the op-ed that she had been SA'd by the time she was of college age, thereby removing any link to Johnny Depp. Having said that, if you look at the excerpt that I have up on the screen right now, you'll clearly see that she says, but I kept quiet. I did not expect filing complaints to bring justice. The title states, I spoke up against SA. So Rottenborn's argument was that she didn't write the title, right? But even if you were to find that she republished it by retweeting it, she wasn't even talking about Johnny. So this little discrepancy here, where the title says, I spoke up, but she says, I kept quiet, when it wasn't about Johnny Depp, I think could defeat Rottenborn's argument that this wasn't about Johnny. Because otherwise, without this discrepancy being pointed out to the jury, they could very well find that the third statement was not defamatory at all because it wasn't even about Johnny. If one element is not satisfied, the cause of action is defeated. I hope this makes sense, and I hope the jury noticed this little discrepancy. So essentially, if they are not convinced by any of her SA allegations, then at least the third statement would be deemed as defamatory. Because that's how these things work sometimes. The jury can come back with a finding that, we don't think statement 1 and 2 were defamatory, but we think statement 3 was defamatory. So it wouldn't be a complete loss on Johnny's part. It would be a partial win. He took the opposite approach to Johnny's side, which is you either believe all of her allegations or nothing. He instructed the jury that if they were to find that Johnny abused Amber once, only once, and it doesn't have to be physical or sexual, it could be verbal, psychological, financial, as per the definition of IPV that was provided by not only Dr. Curry, but also agreed to and reinforced by Johnny himself when he testified that his mother's verbal abuse and her psychological abuse was far worse than her beatings. And Rottenborn, of course, latched onto that and brought it up to the jury and said Johnny Depp himself said that psychological and verbal abuse can be so much worse than physical. This doesn't apply to the SA allegation in the third statement, by the way, because that is an explicit allegation of sexual violence, right? But for the two other statements, in particular the first one, it does make it more difficult for the jury to be convinced that Amber acted with actual malice if they consider that Johnny did verbally abuse her, for example, or he psychologically abused her. He was controlling, whatever it is they may believe, because let's not forget, this has to be a unanimous decision. All it takes is one juror to believe one instance and it's over. So the odds are stacked against Johnny in the sense that he bears the burden of proof. I'm not saying he's going to lose. I don't want to put that out there in the universe. You all know how badly I want for this to go his way. But I'm just telling you that he bears the burden. Now, the same applies to her counterclaim, by the way. She bears the burden. I already have a video with Adam Waldman in the title, if you're looking for it, where I talk about why I think he single-handedly destroyed her counterclaim or any chances of it surviving. You can watch it. Camille's arguments in rebuttal with regards to the counterclaim are really similar, by the way, to the arguments in my video. So it is a good summary of why agency wouldn't apply and why Adam Waldman didn't act with actual malice. He also embraced the weaknesses of his client's case. He told the jury that even if you find she abused him, heck, even if you find that she chopped his finger off with an axe, so basically if you make a finding of mutual abuse, that would still defeat Johnny's claim. Because in order for the statements to be defamatory, the jury have to find that he never abused her. So he's telling them, you can believe she did all these things to him, but what matters is that you also believe that he did those things back to her. They can both be abusive and her statements would still be true. Now, interestingly, with the counterclaim, very briefly, Elaine pretty much admitted to the jury that they filed it in retaliation. She literally said, oh, you want to sue us for 50 million? Okay, fine, we'll sue you for 100. And then she went on to tell the jury, by the way, we don't really want 100 million. We, whatever you come up with that is fair and reasonable to compensate Amber, we're happy for. So at least we know that she's not actually setting out to get 100 million. But that's not necessarily smart from Elaine, because you're not meant to tell the jury that your client was motivated by vengeance, that she was motivated by a need to retaliate, and that there is no legitimate basis for her counterclaim. I'm really hoping the jury is going to see that for what it is. The makeup also came up in Elaine's submissions. I'm sure we all remember how Amber would show up to court with a face full of makeup but not her eyes. I don't know about you, but I always thought that there was some kind of agenda behind that look, and Elaine confirmed my suspicions. She used the fact that Amber showed up to court without eye makeup to show the jury that that's what she looked like when people thought she had no makeup on in the week leading up to the 27th of May 2016. She had makeup on. Her face was caked in foundation, but people thought she didn't because she didn't have any eye makeup on, which may fly and work for men, but women, I mean, come on. You could tell from a mile off she was covered in foundation in court. I don't care what little eye makeup she had, it was crystal clear that she had a cake face of makeup on. I mean, listen, I was gonna pull up an example, but I have no skin makeup on. I have nothing on, I've got nothing. This is what it looks like. this is what it looks like. It's not uniform, it's not one color, you know, it's a myriad of colors. Even if you have nice skin, you're always gonna have some form of, you know, you're gonna be red here, you're gonna be maybe a little bit color around your eyelids. It's just obvious. But that's it for this video. I am filming on the 31st of May, which is a Tuesday. We're in Australia, so we're a few hours ahead of Virginia. And we're basically anticipating a verdict today, technically tomorrow for me, but we'll see. It's something I try not to think about because it only causes me immense anxiety, and I try to keep it out of my head because the thought of the UK happening all over again is enough to make me feel physically ill. I think they were both compelling closing arguments, I have to say. Not necessarily Elaine's part. I think Rottenborn had the more compelling arguments, but Ben and Camille were both as compelling as each other. Where I think Amber's side did well is to focus on the technicalities of the case and to just really draw the jury's attention to the elements of defamation and whether each of these statements tick off the 7 elements. So we'll see how it goes. I think maybe even the next video will be about the verdict, no matter which way it goes. All right, everyone, thank you so much for tuning in, and I'll catch you in the next one. Thank you for all your well wishes, by the way, and your support as well. It's always very much appreciated. Until next time, bye-bye.